All right, everybody, welcome back. This video will be a continuation on the passports and the right to travel, the study of administrative controls on the citizen. This will be a short video because in the next sections coming, I think it's all court cases. So I want to keep the video together. But we'll see how it goes. All right, so to continue, Part B, the non-liberal period between the world wars. In the period between the world wars, the United States terminated the wartime restrictions relating to the departure and entry of citizens from and into the country. And they give you the act. And they actually codified it. But continued them with respect to aliens. Although the United States did not thenceforth restrict the right of its citizens, foreign countries did restrict the entry of United States citizens without passports because they don't know who you are. Reel's article describes the world situation as this. In the confusion produced by the World War, not only did the compulsory passport reappear both for foreign and for internal travel, but it was used much more generally and strictly than ever before. And I think they're really talking about Europe more than here. During this time of general suspicion, of constant vigilance against military espionage, and of food shortage, it seemed the only means of controlling aliens and of assuring the protection of the military and economic interests of the state. The return of peace did not bring with it a return of freedom from travel restrictions except in regard to internal passports, now obsolete in all but a few countries. Economic, social, and political reasons contributed to the maintenance of a strict compulsory passport system for foreign travel, despite the obstacle that it sets up against free communications between states. The severe economic depression which followed the war, affecting both defeated and victorious countries, the widespread unemployment consequent upon the demobilization of millions of men, the removal of populations after the treaties of peace, the revolutionary disorders, the monetary crisis, and the strong protectionism of most governments combined to prevent a return to the liberal pre-war regime, as did also the political changes, such as the Russian Revolution, which produced a very large number of refugees and the disorganization of communication services and of state administrations. Every nation felt obliged to prevent the entry into its territory of unemployed vagrants, spies, political agitators, and persons indulging in exchange speculations, and generally to limit the control of every foreigner. Although the United States had returned to the pre-World War I status respecting the right of its citizens to depart from or enter the country under United States Code 22-11, the effect of the exercise of discretion by the Secretary was quite different from what it had been in the prior period. The refusal by a Secretary of a passport now very definitely limited the area of foreign travel. It could certainly be argued in this period that some logic that the exercise by the Secretary of his discretion in refusing a passport to a citizen constituted in effect a limitation of the citizen's personal liberty, i.e. a limitation on his right to travel, and that such refusal was unconstitutional and without due process of law, and that's how it is today. Let me highlight this. C. Refusal of passports during peacetime. No cases have been found in which the right of the Secretary of State in his discretion to refuse a passport in peacetime to an acknowledged United States citizen as such has been litigated. So it just has never came up. At the present time, well, no one's filing charges. That's what it really is. No one's filing any court cases. At the present time, the Presidential Proclamation of January 21st, 1953, 18 FR 489, I think I'm going to look that up. Presidential Proclamation. Gotta look this stuff up. I'll look for it later, but I wanted to see what would pop up right here. And it looks like nothing. Unless it's this one. All right. Presidential Proclamation of January 21st, 1953, governing the travel control of citizens and aliens during war or national emergency is still operative, and it is today. They codified it. A number of cases that have been found in which the question of an alleged alien citizenship has been determined. A number of cases have been found in which the question of an alleged alien citizenship has been determined. In these, the fact of citizenship was the point in question. And that's why they have that section today, 8 U.S.C. 1503, where they basically state that the passport is an entitlement, right? If you're a citizen or a U.S. non-citizen national, right? So being denied of that, right? You have remedy by being denied just solely on that basis. Because all you have to do is that you prove that you're a citizen or a U.S. non-citizen national. And by law, they need to provide you the passport outside of any national security interest like they're describing here. Although no decided cases have been found, instances of refusal have been set out by Hackworth, Supra, Volume 2. Solicitor of Department of State, December 12, 1906. It is stated that a passport should not be refused on the account of the moral character of the applicant, for the reason that exercise or non-exercise of a legal right should not depend upon the good or bad character of the applicant. That is in a way true. The Secretary of State does not pose as a censor of morals, but if the moral character of the applicant is such and seemingly to involve the public interest or to reflect upon the good name of the United States, no reason is seen why the Secretary should not exercise in this discretion in withholding a passport. And that's, people with famous crimes or did something, I'm saying? Like, they show a repetition of anarchy and violence and robberies and so forth, right? Those people are fall under what's considered a public interest. And if you let him travel and that person never has changed his character, okay, well, now he is staining the good name of the country. This context is what falls under a compelling public interest for the government. September 7, 1906, JHB, I don't know what that is. Promoter of gambling and immoral houses. A passport is not merely evidence of prima facie evidence of citizenship. It is a request to a foreign government to permit the bearer of a passport safely and freely to pass and in case of need to give him or her all lawful aid and protection. In other words, the passport is a request for the good offices of the foreign government, and in this respect is in a rough way equivalent to a letter of introduction. Now, that's what I would look up right here. In the context of a passport asking for permission to a foreign government, I would look up letter of introduction. Why? Because he's stating it here as a thing that's equivalent to a passport. Since a passport has never been required, right, outside of national emergency context, right, then this has always been the way. You have always been responsible to introduce yourself to the country that you plan on visiting. The passport just makes it simpler. And of course, that's a benefit of the federal government. And they could restrict your use of it under, of course, specific criteria. It may well be that we may not care to give a letter of introduction and request good offices for a citizen of the United States whose conduct has evidenced by his past and present actions is likely to embarrass the United States system. United States. It says it may well be that we may not care to give a letter of introduction. What does that mean? It's a government letter? Right, just by his past and present actions is likely to embarrass the United States. Such a case would seem to be a proper one for the Secretary to exercise his discretion and refuse the issue of a passport. Examples: promotion of gambling and immoral houses, prostitution, unlawful activities, blackmail, past conviction of crime, evaders of justice, political adventurers, revolutionary radicals, persons engaged in illicit traffic of narcotic drugs, paroled criminals, those using foreign passports, those participating in local foreign politics, expatriates, etc. A lot of this, I can't even say that. Paroled, of course, means that you're still on their time. But then it says past conviction of a crime, so it would be a specific crime, so maybe murder would fall under it. D, the war power and personal liability. Broadly speaking, constitutional protection of personal liberty operates in war as well as in peace. The necessities of a war or emergency situation must, nevertheless, be considered in relation to those liberties and at least a minimum balance kept between them. Otherwise, the path leads to star chamber proceedings and ultimately to dictatorship. The war power of the national government is the power to wage war successfully and extend to every activity so related to war as substantially to affect its conduct. Kramer versus the United States. I'm going to highlight that. I'm highlighting all these court cases. And because I'm going to make a video on all of them. Whether they're one at a time or two at a time, I don't know yet. So far, there's like 6. So, this is the first time I've ever seen Court Listener on my computer. And Justicia never showed up. But then, this was crazy. Look at case text. Don't exist no more. Westlaw bought them out and then shut down the website. Court Listener is a great website. I highly recommend that. So this is what year is this? 1945. So that's going to go, I think, right here. 1940, 1941, and then 1952 for that court case. So yeah, there's 1, 2, 3, 4, 5, 6. So, and I'm confident there's going to be at least 2 more. But the court cases are also here in this book. So we'll see what effect that has in comparison to really the actual case. Because I think it's mostly just opinions in this book. And here they give a lot of court cases right here pertaining to the war power and personal liberty. Kramer was the first. Certiorari denied, so the Supreme Court didn't want to hear it. Again, Supreme Court didn't want to hear it, and Atherton. It embraces the nation's whole system of internal and external regulations by which the nation undertakes to preserve its life. This is the war powers. I don't think I'll have to look up these cases, because these are describing the war powers on how its effect has on anything else. It is a power to wage war successfully, and thus it permits the harnessing of the entire energies of the people in a supreme cooperative effort to preserve the nation. Rehearing denied, certiorari denied. The Supreme Court indicated the broad scope of the war powers in U.S. versus McIntosh. So 1931, the Supreme Court indicated the broad scope of the war powers. I wouldn't doubt that this is one of those cases that was used by Roosevelt to do what he did with the war powers, with the War Powers Acts that he did in 1933 and so forth. It says, from its very nature, the war power, when necessity calls for its exercise, tolerates no qualifications or limitations, unless found in the Constitution or in applicable principles of international law. In the words of John Quincy Adams, this power is tremendous. It is strictly constitutional, but it breaks down every barrier so anciently erected for the protection of liberty, property, and of life. To the end that war may not result in defeat, freedom of speech may, by act of Congress, be curtailed or denied, so that the morale of the people and the spirit of the army may not be broken by seditious utterances. Freedom of the press curtailed to preserve our military plans and movements from the knowledge of the enemy. Deserters and spies put to death without indictment or trial by jury. Ships and supplies requested. It's not requested. It's requisited. Requisitioned. Oh my God, I didn't know that word. Ships and supplies requisitioned. Oh man. Property of alien enemies, therefore under the protection of the Constitution, seized without process of and converted to the public use without compensation and without due process of law in the ordinary sense of that term. Prices of food and other necessities of life fixed or regulated, railways taken over and operated by the government, and other drastic powers wholly inadmissible in time of peace, exercised to meet the emergencies of war. Notwithstanding the scope of the war powers, which might be constitutionally exercised during periods of war or emergency, those powers are subject to applicable constitutional limitations, and they repeat McIntosh and a handful of others. The guarantees of the Fifth and Sixth Amendments restrict the powers of the national government within the limitations of due process in the exercise of war powers. Let's restate that. Notwithstanding the scope of the war powers, which might be constitutional exercised during periods of war or emergency, those powers are subject to applicable constitutional limitations. That's good to highlight right there. And then the second part, the guarantees of the Fifth and Sixth Amendment restrict the powers of the national government within the limitations of the due process in the exercise of war powers. Thus, it is evident that a balance must be maintained between the exercise of the war powers of the government and the constitutional rights of the citizen. Depending on the factual situation, Mr. Justice Murphy, in the dissenting opinion in Korematsu, probably Japanese, Korematsu versus the United States, indicated his ideas respecting the test to be applied. The test whether the government, on the plea of military necessity, can deprive an individual of constitutional rights is whether the deprivation is reasonably related to public danger that is so imminent, immediate, and impending as not to admit of delay and not to permit intervention of ordinary constitutional process to alleviate the danger. And this right here, I would think is important, right? The reason why is because in today's language, right, in the code, they speak of it in the context of you going to a specific place. So say we're at war with Russia or whoever, China, right? Then there is no real reason not to be able to go to Mexico. Right? They, no doubt, they have the right or possibility to restrict your travel, but it's restricted through the context of the Constitution. It has to be in line with what the intent of the war powers and emergency powers encompass. This is why the language has changed in today's day. Whether the courts will ever go as far as the Murphy test is questionable. In fact, it is questionable whether a test can be devised which could reasonably be applied to all factual situations. Now, gotta be at a time. But the problem with that is that it's the State Department. It's an agency. And they can't have courts. All that, especially today, in today's day, those courts are disappearing. Those administrative courts. They can't adjudicate this. This is why, as of right now, they will give you an administrative hearing for a variety of lists, a variety of things, right? Whether it's your identity, whether it's drug convictions, whether it's some aspect to that regard, right? To try to sell yourself, to convince them at the hearing. The one that will call a handful that they do not give a hearing for is, of course, putting the Social Security number. Furnishing the number is not mandatory. They don't have a hearing process for that. You have to take it to court because it specifically deals with something that's voluntary that is affecting your right to travel. The other aspects are incidental, like a birth certificate or a birth record, right? If your parents choose not to get a birth certificate because they get birth at a hospital, right? That's, or whatever, right? That's one thing. But you, as a prudent person, should be keeping records of your own family. Regardless if you say you got a home birth, right? You know what I'm saying? If you got a home birth, you got your own record. Okay, well, that is the record that you could use for a passport. It doesn't have to be the birth certificate. Jordan versus Rubio case is a prime example. If you guys haven't read the case or watched my video. Prime example of that. She didn't use no birth certificate. It's always going to be. The thing is, though, this right here would apply that some type of court needs to be applied, right? Like every situation, like with trust law, business trust and stuff, right? Every last one of them is independent and has to be broken down separately. There is no unified anything that would label a trust or business trust as something other than a specific analysis of the entity of the trust indenture. No doubt they have a criteria for what makes a partnership, corporation, or association, but the only way to determine that is to look at the indenture. That's the substance. The fighting powers of the United States under the Constitution, reprinted in Volume 55, Congressional Record, Part 8, seems to indicate the most practical application of the limitations of the Fifth Amendment upon the war powers. That power expressly conferred and absolutely essential to the safety of the nation is not destroyed or impaired by any latter provision of the Constitution or by any one of the amendments. These may be all construed so as to avoid making the Constitution self-destructive, so as to preserve the rights of the citizens from unwarrantable attack, while assuring beyond all hazard the common defense and the perpetuity of our liberties. They rest upon the preservation of the nation. Let's highlight that. The power expressly conferred and absolutely essential to the safety of the nation is not destroyed or impaired by any later provision of the Constitution or by any one of the amendments. Part E. Refusal of passports during war and national emergency. The Act of May 22, 1918, which restricted the right of citizens to depart from or enter the United States without passports during war or national emergency, when the President finds that the interest of the United States requires such restrictions, was repealed by the Immigration and Nationality Act of June 27, 1952. The repealing act, however, included similar provisions as a part thereof. See 8 U.S.C. 1185, and I looked that part up already. That's in this book. Let's go look at it now. 8 U.S.C. 1185. Doing this is what's going to make this video a little bit longer, but I'm going to try to keep it within an hour or so. And here it is. Restrictions and prohibitions. Unless otherwise ordered by the President, it shall be unlawful for any alien, and this will for any person to transport or attempt to transport from or into the United States another person with reasonable knowledge, with knowledge or reasonable cause to believe that the departure or entry of such person is forbidden. These things like are given though. You know, false statements, bringing someone in illegally or some shit, right? For any person knowingly to furnish or attempt to furnish or assist in furnishing. This hasn't changed from the other video. That's in it. 1185 was in the earlier section. That's what the history showed, and they're repeating actually the 1918 stuff. Where did I leave off at? Well, actually, this is 1952. But this right here, fuck, I want to go look. All right, but contact with the National Archives Office of the Federal Register reveals that the National Emergency Act of 1950, see Presidential Proclamation number 2914, notes preceding section 1, 50 U.S.C., Act 3 miscellaneous, proclamations and executive orders, and the Presidential Proclamation of 1953, number 3004, control of persons leaving or entering the United States. For current regulations issued hereunder, see 22 CFR 53.1 and through 53.8. Revised as of January 1966, are still in effect. The enforcement of this act with respect to citizens, 8 U.S.C. 1185b, is an exercise of war powers. Let's see if they state that. Except as otherwise provided by the President, subject to such limitations and exceptions as the President may authorize and prescribe, it shall be unlawful for any citizen of the United States to depart from or enter or attempt to depart from or enter the United States unless he bears a valid passport. Now, what did they not do here? They didn't tell you the context and in what way they could do this to you. They don't tell you it's the war powers. It's specific context. All right, the enforcement of this act with respect to citizens, and they give you the citation, is an exercise of war power. See, Schickfi versus the United States, which I'll look that up too. I don't know if I'll read it, but one never knows. Like another case text. It's 277F 762. 762. Oh man, I can't even search this. $726. It might not even be here. 726, 774. Nope. I'll look for it later in court, listener. And would therefore seem to require a balance between the constitutional rights of the citizen and the exigencies of the war or emergency situation. This is exemplified by the course of decision by the courts. And this is where they start talking about court cases. It's part of this chapter. Yeah. So with that, I'm going to end this video right here, because these are all going to be the substance, right? The context and where and how the government could restrain your right to travel or access to a passport and stuff. So I'm going to start right here with Bauer versus Atchison, 1952, which of course I'm going to look up right now because, you know, I just want all the cases. Yeah. All right. So with that, I'm going to close this out and end this video. Hopefully you guys learned something. If not, I don't know what to tell you. The next video will be fully on court cases. This right here is going to be a lot of videos because more than half this book is all court cases. It looks like it's not the full court cases. It is the opinion of the judge and dissenting opinions. So like it starts on like page 35. So we'll see after this section. All right. And with that, I'll talk to you guys later. Hopefully you guys subscribe and share my life, share my videos. Have a good one.